This is another continued hearing in the matter of matter of Colon Township versus Alfred E. Yoder and Joanne Yoder. There are two files, 25040CZ and 25533CZ. These are circuit court matters. I inherited this case earlier this year from Judge Stutzman when he disqualified himself, made a number of rulings, had a number of hearings. Keep hoping this matter will be over and completed, and the defendants have filed additional pleadings. I'm not sure I exactly understand everything. And then again, some pleadings were filed just the other night, January 21st, which was Wednesday before the pipes broke. So I had made my rulings. Mr. Thornton, on behalf of the township, submitted the orders for presentment. Defendants filed these additional pleadings, and here we are again. Mr. Thornton has filed a response pointing out that
the judge opens yet another continued hearing in Colon Township versus Alfred and Joanne Yoder, clearly frustrated that this case refuses to end. He explains he inherited the mess after another judge stepped aside. Rulings were already made, and yet new pleadings keep flooding in. The tone is set immediately. This court wants closure, but instead gets confusion, late filings, and motions that seem to multiply overnight.
Irregularities in the defendant's motion and pleadings, and he's asking for sanctions on behalf of the township for continuing to have to come back here regarding these motion hearings. So, Mr. and Mrs. Yoder, you're the motion filer here. What are you asking me to do?
Your Honor, we're here on our written motions challenging the accuracy of the proposed order and opposing sanctions.
All right, what's your challenge to the accuracy of the order?
It's very misleading. And it does not match the transcript, not even close.
What part of it don't you like?
Most of it.
Well, my reviewing of it is it was consistent with the orders I made here in the courtroom. They don't have to exactly track where it was said in the courtroom. You filed these pleadings, and as I've said repeatedly, someone's helping you, someone without a law license, but access to Chat GPT or other AI generated stuff. They're terrible. Their pleadings are terrible. They're leading you down the incorrect path. They're going to end up costing you lots of money, and they filed fraudulent or incorrect, at worst fraudulent, at best incorrect or lazy or incompetent pleadings on your behalf. They cited authority that doesn't exist. Anyway.
The defendants challenge the accuracy of the proposed order, claiming it does not match the transcript. The judge pushes back hard, saying written orders do not need to mirror court transcripts word for word. Then comes the bombshell. The judge openly accuses the defendants of being guided by someone without a law license using ChatGPT or AI tools. He calls the pleadings terrible, misleading, and legally unsound, warning they are being led straight into financial disaster.
And then they can't speak for you because they aren't lawyers. And I can't go back and redo the past. I told Ms. Wertelman this, I told others. If you had a competent lawyer at the start, we'd have been a lot better off than we are here.
But, Your Honor, what do we have missing?
All right, well, we'll get to that. All right, so you tell me you file these things, you object to everything in the order. You don't like anything that's in it. I need you to be a little more, now you do have these pleadings that you filed which state these things. All right, well, all right, so you've got defendant's motion order to show cause in 2540 and 25433. And you've got a motion to strike proposed order of December 4th. Law requires that a written order match the oral ruling. Proposed order mischaracterized what the court actually did. The judge may not mock himself to avoid judicial duty. And then eventually object to the entry of proposed order. So that's the first thing. You're objecting to the entry of the orders. Mr. Thorne, what's your response?
Your Honor, the court's rulings in the hearing held in both of these cases on December 3rd of 2025 were not extensive or complicated. The two proposed orders that I prepared at the court's request with regard to the denial of the order's motions on December 3rd, 2025 are brief, accurately reflect the court's rulings on that date, and if the orders had competent counsel, would have entered without objection. Well, that has not been the history in these cases.
The township's attorney responds methodically and ruthlessly. He explains the orders were simple and accurate, but instead of accepting them, the defendants filed page after page of motions, objections, and affidavits, often without proper notice or service. He highlights repeated violations of court rules and emphasizes that the township keeps being dragged back to court to defend against filings that never should have survived basic legal scrutiny.
Instead of those simple, straightforward orders being entered by the court, the orders file a motion to strike, 9 pages long, a motion for an order to show cause, 6 pages long, objections to entry of proposed order, 8 pages, and then a week or so later, an affidavit of factual observations, 5 pages. The orders in violation of the court rules then failed to follow the court rules by failing to serve those documents on me as the township's counsel of record. The orders in violation of the court rules to file with the court or serve me with a proposed order that they believe complies with the court's rulings on December 3rd, 2025. And they failed to follow the court rules to schedule a hearing and file a notice of hearing regarding their motions. I think they belatedly, after the court scheduled the hearing on its own, did eventually file a notice of hearing.
I advised them that they hadn't filed a notice of hearing. And then they said, well, what do we need to do? And I'm not sure, but I think then they tried to remedy it.
It's been my experience that when a party fails to set motions for hearing, fails to file a notice of hearing, and fails to file an alternative proposed order to the order they're objecting to, the court would not set a hearing date to the multiple due to the multiple court violations. However, that is not the case in these cases. The history in these cases is that no matter what the orders file, no matter how many court rules are violated, the court sets hearings and Colon Township is required to defend. In addition to the above, the order's motion to strike includes an alleged quote from Tiedemann v. Tiedemann, 400 Mich, 571, 1971 to support their motion. The quote, and it is a quote in their motion to strike, does not exist in the Tiedemann case, and the subject of the quote isn't even a holding in the Tiedemann case. In short, the orders either intentionally or through gross negligence attempted to mislead this court. The order's motion to strike includes an alleged quote from a case they captioned In Re Estate of Temple Marital Trust, 278 Mishap 122, 2008, to support their motion. This case, the case with the site of 278 Mishap 122 is actually captioned Temple v. Temple, and the quote in the order's motion does not exist in the case, and the subject of the quote is not even a holding in the Temple case. The Yoder's motion to strike contains an alleged quote from an alleged case captioned Palazzolo versus Gorsica with an alleged cite of 200 Mishat 27, page 271, 1993 case. I could not even find that case by searching the names or the site. In short, the Yoders and those persons assisting them believe that when this court holds a hearing on a motion and makes the rulings on that motion, the order entered by the court in regards to the hearing must mirror the transcript of the hearing word for word.
Then it gets serious. The attorney reveals that the defendants cited court cases that either do not exist, were misnamed, or contained quotes that were completely fabricated. One alleged case cannot be found anywhere. Another was miscaptioned. Quotes cited were never part of the holdings. The attorney states plainly that this is either intentional fraud or extreme negligence. The courtroom energy shifts from confusion to consequence.
I refer the court to page 7 of the Yoder's motion to strike, where one of their relief for request states, direct plaintiff's counsel to submit a corrected order that mirrors the transcript word for word. As the court is aware, there is no court rule or statute that requires this, and to my knowledge, there is no Michigan court that would require this. If this were the case, then a transcript would be prepared after every hearing, and the judge presiding over the hearing would simply sign the transcript. After I filed and noticed for hearing my motion for sanctions, the Yoders filed an objection in response to request for sanctions, claiming there is no basis for sanctions. MCR 1.109E states, the signature of a person filing a document, whether or not represented by an attorney, constitutes a certification by the signer that, to the best of his knowledge, information, and belief, formed after reasonable inquiry, the document is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law.
The judge agrees the orders are brief, accurate, and reflect exactly what was ruled. He explains that if these pleadings were filed by licensed attorneys, bar sanctions would be inevitable. The defendants double down, insisting the orders are misleading, but the judge reads the orders line by line and confirms nothing was altered. The defendant's argument collapses under the plain language of the rulings.
I'm going to go out on a limb and say I don't think the Yoders or whoever prepared these documents on their behalf ever read the cases they were citing. If they did, they have committed intentional fraud on this court. On behalf of Colon Township and its taxpayers, I'm requesting that this court enter the two orders I submitted that accurately reflect the court's rulings on December 3rd, 2025, and grant the township's motion for sanctions, ordering that the Yoders pay additional costs and attorney's fees to Colon Township in the total amount of $1,624.68, which is the actual cost that Colon Township and its taxpayers have incurred in these matters since December 3rd, 2026. I would propose that that amount of $1,624.68 be divided between each case, since the motions were duplicated in each case. That half amount would be $812.34 in each case. Thank you.
All right. Mr. and Mrs. Yoder, the two orders that were presented, as Mr. Thorne stated, are brief, concise, and consistent with what the court ordered on December 3rd. They're asking for sanctions. We cited the rule. the person signing, for one thing, you're never very good on the procedural stuff. Getting notices, filing notices, getting dates, serving the other party. And he objects to my setting these things without you doing it right. Judge Stutzman might have just bounced it, but I wanted to get it to the next step, which is where we are now.
The court grants sanctions, ordering the defendants to pay $1,624.68, split between both cases. The judge makes it clear. These filings violated court rules, cited non-existent law, and wasted taxpayer resources. He signs multiple final orders, preserves the defendant's right to appeal, and issues a final warning. Any further improper filings could trigger even harsher financial penalties. Court is recessed with a clear message. This case is over unless the Court of Appeals says otherwise.